a different decision. But the highest court still is then legitimately able to say, no, we still stand by what we said, right? So,
well, there's two reasons. First, it goes through two courts. It doesn't just go through one court, because courts don't always start off at the Supreme Court of Appeal. They have to start off somewhere. So the first has to, and then the reason is that lower courts are easily more manipulated because they get paid less and there's less security. So the reason why they go to a higher court is because not just one person will be hearing the matter and they get paid more and they've got more security. So it's harder to tweak the thing at a higher level than it is to tweak it at a lower level. And at a lower level, is not as many, they're not in communication with each other. Meaning that whatever someone is doing in Nelspruit, the magistrate in Limpopo doesn't know what they're doing. But in higher courts, they are more deliberative because since they wear wigs and all that, they think they're posh. So in Cape Town, the guy calls the guy in Nelspruit and says, hey, you know, I did. So there's more unity in the decision that is reached than what would have been at lower level.
Okay. I agree with the majority of what you said, but like if the most corrupt people in society are the richest people in society, doesn't it mean that there's more likelihood of manipulation in the higher, where most prestigious courts than there would be in the lower? Just like think about it.
Okay, so I do not feel that it's a good thing because of the fact that justice in everyone else's eyes is different. So let's say that a smaller court in that community, gay marriage is considered, well, it's not considered as bad. But now in the higher courts, and they discuss this among themselves, that gay marriage is bad because of their situations. But now in this situation, gay marriage is accepted and it's not as bad thing. So then how could justice be applied there if, because considered to them it's an injustice not to be able to marry who you want to?
I actually, and like my reason for thinking it's a terrible thing links to what you said, right? The higher up the ranks people climb in society, the more detached they are from what's going on in the ground in society. What that essentially means is your Supreme Court and Constitutional Court judges are majority judges who only really interact with other people on their same level. That means that their whole decision-making metric is of that level. And the majority of times, it's a purely scholastic decision-making metric, right? So everything they see, everything that's brought before them is like intellectual challenge and intellectual case. What smaller courts are more able to do is intimately relate with what people's lives around the scenario are, right? And I think that's the one advantage of having like a more decentralized system than having like one uniform system. And like the pressures, and this is the important thing, right? The pressures on, for example, constitutional court deciding that gay marriage is illegal in like Uganda, for example, are extremely high. The Constitutional Court is almost under an obligation to decide that it's illegal because that's what almost everyone on the ground wants, right? And I think that's also extremely different. On top of that, I don't think that it's fair for every time I want to challenge a decision, I have to ask you to change your original decision. The fact that you made that decision means you genuinely believe that that decision is correct. The likelihood, and this happens a majority of the time, of like higher courts changing the way they ruled their initial cases is extremely low because everyone believes that, you know, the way they analyze things is always perfect. So like there are a number of difficulties there.
No, essay, you're not allowed. Just essay asking questions, let's shoot him.
It's going to be
Last minute.
I'm just going to add on to that. Isn't that also why America has like a jury of peers for them to decide what's normal in their circumstances and to judge upon that?
That's true. I mean, like America, that and the fact that Americans just like they have issues. Yeah, true. And I don't know if it's a better system, but it works for me, right? Right. And this links back to the first one we spoke about last time, right? Role of the court in enacting social change, right? So because the court generally has a responsibility to look out for everyone within society and to ensure justice for everyone within society, does the court then have a duty to positively change people's lives in a certain way? So for example, the case of a United States case. I think the law students will know this. It's R versus something, which is the name will come, right? And this is the court case that basically legitimized mixed schools, right? It was a black kid who wanted to go to a majority white university. This was like after the whole slavery thing, and they went to court and the court said, yeah, you know what, you can go to that university, you have a right to do that. So should courts be able to do that, or is it more of a decision that should be taken by people who we have chosen to represent us? Because remember, judges are people that other people choose to go and do other things. We have absolutely no say on who sits in the bench in our courts. We do have a say on who sits in parliament. So do you think that these decisions are best left with people we choose and people who go to parliament, the Julius Malema's, or do you think it's better served by more educated, more liberal judges? Right? I'm not going to take any, just like it's a question I'm going to put out there, maybe you should just think about it. Right? Now, generic flaws to court systems, and there are three of them, right? There's the inherent bias problem, the board justice phenomena, and the binding precedent which we've just been talking about. The inherent bias problem is this, right? Regardless of what the law is, and there's a very interesting quote by one of the American really good legal writers, and he says that the way the judge decides how a court case goes can be influenced from anything ranging from what the law is to what he had for breakfast. Because regardless of what the law says, there's always like so much room for interpretation that allows judges to decide certain things. So the judge, for example, can decide whether you get 10 or 15 years. That is completely within the judge's hands. So that inherent bias generally means that the court system will always not necessarily be fair. Because there's some judges, and this is how lawyers play judges, there's some judges who are conservative, so a lawyer will know to have more conservative arguments. So those judges who believe that, you know what, we shouldn't kill people, whatever. There are other judges who believe, we should kill people. And when you come before those judges, you come before them with those perceptions, so you know what to argue. There's always going to be an inherent bias when you have an individual deciding what the fate of another individual is, right? The second one is the board justice phenomenon. If the best lawyers in the country are the most expensive lawyers, this means that the poorer people in the country aren't able to tap into the kind of legal representation that richer people are able to. So this means for the same crime, richer people will get lesser sentences or no sentences, but poorer people will go away to jail for a really long time. That's another thing that's extremely problematic. Do you want to say something? Right. And then the binding precedent which we just talked about, right? Now, the last one before ICC, international law. So we're going to look at three things. International law, international courts versus governments, international courts versus individuals, treaties, conventions, and jus cogens, right? Who knows what jus cogens is? Right, no one. So basically, the biggest problem with international law is that no one is bound by anything. Generally, no country has like a duty to do anything to another country. And the reason I say this is because there's generally no sanction when you choose not to do that. So in order for Botswana to take South Africa before the International Court of Justice, South Africa has to first respect the authority or the jurisdiction of the International Court of Justice. So if Botswana sends South Africa a letter to say, look, we're going before the ICJ on Monday, SA can just say, look, I don't recognize the ICJ, try something else. This means Botswana has absolutely no remedy against South Africa in instances where South Africa does something wrong. And that's the majority of instances why you see things like escalating into war and whatnot, right? So that's problem number one. So in terms of international courts versus governments, the biggest problem, and this is how like you win pragmatically all these philosophical debates, is even if it's a nice idea to do all these things, we are unable to do them. Because unlike a state where every citizen accedes to the authority of the government, when a country decides that it doesn't want to accede to the authority of the government, that country, we believe, is protected by sovereignty. And that sovereignty is what stops us from being able to act. So in terms of international courts versus governments, International courts versus governments, that's basically what I'm going to say, right? That there is no real framework at international law that allows us to hold people accountable or to hold countries accountable. However, with regards to very few things, there's what we call jus cogens. Now, jus cogens is basically a uniform set of rules that applies to absolutely every state, whether they like it or not. So with these, when South Africa can't say, try someone else, they absolutely have to follow those rules. And you're looking at things like laws against torture, laws against crimes against humanity, laws against genocide, laws against crimes of aggression. All of those things fall into the category of jus cogens. Now basically what that means is if a country doesn't follow those rules of jus cogens, then every country in the world has a duty, not a duty, a right to act against that country. So generally what will happen is your regional blocs will sanction that country, which is classic case was Libya, when Libya started feeling smarty pants and doing all these random things. The United Nations decided they were going to get together and sanction Libya. So that's because what Libya was doing was a violation of jus cogens, right? So jus cogens are those 5 things that absolutely everyone has to follow, whether they like to or not. Unfortunately, it seems like these things don't apply to America because America is torturing people in Guantanamo Bay, but no one seems to remember jus cogens. Let's look at the second idea. The idea of international courts versus individuals. Just with the first idea, when you're talking about international courts versus governments, you're looking at basically your International Court of Justice, the ICJ, and your World Court, right? Those are 2 courts that basically settle between governments and other things. And the ICC to a very minimal extent, right? When you talk about international courts versus individuals, this is where the ICC comes in. Because the ICC has a mandate to try anyone who does like any of these bad things, and so they have the right to go for individuals. So the ICJ, for example, has absolutely no right to call or sanction any one individual to come before it, because that person doesn't have locus standi, basically doesn't have a right to be.
Sorry, this is a technicality, so I just want to know. When, like, according to these courts now, someone like a country is tried, who's being held responsible, the country or the rulers that actually made the decisions, whatever? Yeah. And like, the other question is, what if it's like a social norm for like genocide or whatever the case may be? It's not like, or cannibalism, they can take Papua New Guinea as an example. Like, who's being tried there, according to the jus cogens?
You can't try. Basically, if you're trying the country, you're trying the government, you're trying the people, you're trying everyone. Because whatever sanction you're going to pass against the country is always going to affect everyone within that country. So if it's economic sanctions, if it's no-fly zones, any sanction you're going to pass is always going to affect everyone within that country. So every time, it's always going to be a representative from the government, usually like a Minister of Foreign Affairs, the President, or the Chief of Staff, whatever the President is responsible for all the other members of Parliament, basically. Those are the people who live here, but it's like, even if you read the case name, it's going to be country A versus country B, and the whole of country A again has a responsibility to act accordingly, right? So international courts versus individuals. I think I'm going to leave this one out for when I'm talking about the ICC, because there's quite a bit of material under that. I'm going to look at very few juicy examples, right? For international law, that was just notes for me. So does anyone not understand anything with regards to international law? Is there anything else you want to know? So basically, a lot of the times, if a motion says that as an international community we want to do A, or as the United Nations we want to do A, basically, they generally can do it theoretically, but a lot of times it doesn't breed any results unless the international community as a whole decide that they're going to sanction that country. Because if they don't sanction that country, then the courts generally can just pass all these laws, but those laws are ineffectual at the end of the day, right? So let's look at the ICC. So I've set up a yardstick here, which I think is generally fair. If Michelle disagrees, we can add whatever you want to add into the yardstick. Now, what I want to start with saying is it's extremely important to understand that before the ICC is this international organization that represents the rights of millions and millions of people, regardless of what jurisdiction they're in, the ICC is a court of law. What that then means is we need to judge the ICC based on what it is by looking at the same way we judge other courts similar to the ICC that carry out the same kind of thing as the ICC. So you judge the ICC in the same way you judge a lower court, or in the same way you judge your ICJ, right? So what metric do we use to assess the legitimacy of any court generally? Number one, I think, is it governed by a strong constitution that clearly sets out its functions, limitations, and explicitly dictates the procedure for things like appointment of judges and tenure. So is the constitution of that court clear enough with regards to what that court does, who can come before that court, and who can sit on the bench of that court? If that constitution is clear enough, then that goes a long way in proving, that the court has some legitimacy, right? Number two, is it recognized as an independent organization whose foundation is built on principles of neutrality, objectivity, and equitable distribution of justice? In short, basically, is it unbiased? So is it an objective body? Can it be neutral? Do the people who sit on the bench have the ability to be neutral without being like forced into certain positions by foreign states, as people always claim with the ICC in America, which is total bullshit, right? Number three, does it procedurally respect the fundamental rights of the accused and allow for an environment within which a fair trial can occur? This is something that's extremely important at law, because even though we accuse someone of doing something, we want to make sure that when we bring them before a court, we bring them before a court in a way that's fair, so they can get a fair trial, so that the judgment is fair. So to the extent that you can prove that any court has the ability to do that, to create an environment where every trial is fair, by having like neutral parties come in and adjudicate or whatever, then you prove that that court has legitimacy. And I must say, you're going to need to prove all of those things. One of them isn't enough, right? Number four, do its structures support policies that actively advance the equitable representation of all the demographics it purports to preside over? So basically, does it have policies to say that because we're an international court, we're not just going to have judges from Europe, we're not just going to have judges from America, we're going to have judges and staff from every place within the world. So we'll have like 5 from Africa, 7 from Europe, 10 from America, 15 from New Zealand, and a couple from Potchefstroom. Can it do its structures allow for that, right? So to the extent you can prove all 4 of those things, I think you go a long way in proving that the court is legitimate. But before we get into that, let's look at a few things that people often misunderstand about the ICC, right? Number one, and most importantly, the ICC is not a part of the United Nations. So it isn't like the UNHCR, it isn't an arm of the United Nations. It's an absolutely independent body from all of these international organizations. So bias coming from them is extremely difficult to prove. Secondly, right, it has a division called the Office of the Prosecutor, which is responsible for receiving and examining referrals. So basically what happens with ICC is we don't just decide that we generally want to go after anyone. What needs to happen is someone has to refer a case to us and say, look, I think like our neighbor here, Gaddafi, is doing some shit, can you like check into it, right? Or because of a reasonable source, like if there's legitimate information to show that something bad is going on, then the chief prosecutor has the right to take that decision to go and investigate. So we don't just investigate anyone, there needs to be a set of circumstances that lead us to reasonably believe that we should investigate.
With regards to that, then that would now in Kenya with the violence of Kenyatta and with what they've done, and who reports that is the citizens in the country that say there is X shit going down, our courts can't handle this, could you please do something about it?
Right. I'm going to get to that when we specifically talk about Kenya. Right? So, like I said, it works as a system of referral. So there's state referral, right? So states can refer. There's what I just spoke about, where we have legitimate information from a legitimate source, and the chief prosecutor decides that he's going to investigate. Also, there's Security Council referral. So if the UNSC collectively decides that, look guys, we don't know what to do right now, but we're pretty sure that some shit is going down in Syria, then they can refer that case to the ICC and the ICC can investigate. So let's establish this first. The ICC has absolutely no right to go after whoever it wants to go after on any given day. Moving on, right? ICC was established by the Rome Statute, and